And first of all, a very warm welcome to all of you from all of us here at Jones Chase, and welcome to the next Your Employment webinar in the series, which provides you with essential employment law and HR updates. For those of you that who are new to our webinars, we are of course Jones Chase, a firm of specialist employment lawyers, and we act for a number of companies from PLCs all the way through to startups, and also some fantastic individuals as well. And we have a very high success rate of looking after those that we represent. And we're truly delighted to have you with us once again. And I'd just like to quickly introduce the team so you know who's going to be speaking to you today. Going clockwise from my screen at least, we've got one of the firm's partners, Shona.
Hello, good afternoon.
And one of the firm's senior associates, Harriet.
Hi, everybody.
And the firm's new paralegal, Dominic.
Hi.
Who's managed to successfully mute and unmute himself. Very obviously a pro doing webinars, Dom. Yeah, there you go. Okay, great. Right, and just moving on a little bit. So in terms of the format for the webinar, if you want to ask questions, please use the Q&A box. And if you want to do this anonymously, you can hit the anonymous button. There'll also be a chat function running as well, but please do bear in mind that the chat box isn't anonymous. So if you don't want your name or your name of the company to appear, please hit the anonymous button on the Q&A box. What we do quite like as well is if you are lodging a comment or putting something into either box, and there is an option for you to select all panelists and attendees rather than just all panelists. So if you don't mind, please select all panelists and attendees so people can see what you're saying. It just helps to keep the conversation going. If you want to speak live to us, please write that in the Q&A box or the chat box, and either myself or one of the team will come along and meet you. And I should add that we are recording the webinar, which allows us to distribute it to a much wider base than those that could attend at 4 o'clock today. So please do bear that in mind if you're asking questions and you want to do so on an anonymous basis. I should emphasize that the points that we're covering today are not formal legal advice, and so much depends on the facts of each individual case. And sometimes the approach you take in one case is not the approach that you take in the other. So please do not rely upon this webinar as constituting formal legal advice. If you need an opinion on something, by all means drop us a line, we'd be delighted to help you. Okay. As a quick reminder, the information that we're covering today is accurate as of 4 o'clock on the 25th of November. Things in the world of employment law are always changing quickly, so drop us a line if you have any questions. And we do appreciate that everyone's time is precious, so we are going to finish at 5 o'clock today, if not before. And we do like helping people, so if you have any further inquiries that you want to run past us, or if you know any other companies or individuals that could benefit from help, please do introduce us, and we do very much like receiving referrals. Okay, so moving on with the content of the webinar, and the first topic is about disability discrimination, and Shona is going to tell you about a very interesting and important case that that's been publicised recently. So Shona, over to you.
Thank you, Dean. So this is a case about love and work and loss. And it involves a Mr. Sullivan, and the employer is Berry Capital. Mr. Sullivan was employed by Berry Capital in September of 2009, and he was a senior sales executive. Berry Capital raised funds in mostly Europe and the Middle East, and used those funds, that capital that they raised, in order to fund their clients that were in America. Hedge funds were mostly made up of their clients. So Mr. Sullivan was recruited in September 2009, and he worked quite successfully through to 2013. In the period of September 2009 and 2013, he was late a lot. His timekeeping left a lot to be desired. His record keeping left a lot to be desired. But he was an employee, and he was there. And then in March of 2013, this is where the love comes in. He meets a Ukrainian woman, and he goes out with this woman for a few months. And whilst that's going on, and at the end of that relationship, which ends in May of 2013, so last 2 months, Mr. Sullivan believes that he is being followed by a Russian gang. And that's why I mentioned that she was a Ukrainian woman, otherwise it wouldn't be relevant. That he's being followed by a Russian gang and actually persecuted by this gang. And so he starts having delusional persecutory feelings, is how he describes it. So that's the period of March 2013, and that actually carries on until September 2013. And it's important to remember those two dates because the delusional events he has in those time it's at its peak. He stays at work all that time, carries on working, but discusses a lot at work about being pursued by this Russian gang. He's still being late. He's still not keeping his records properly, etc. And then he goes into some therapy in 2014, and he's okay again. He gets his life back. Still have some delusionary issues arising, but his life comes back. And then we fast forward to September of 2017, and Mr. Sullivan is dismissed. And he's dismissed because he's had another episode of delusional activity in a period in between April and June of 2017. And this other episode related to negotiations for a pay increase. So nothing to do with the Ukrainian love, but to do with negotiating pay. And he starts, as I say, again, having delusional episodes, still involving this Russian gang. He gets dismissed in the September of 2017, and Mr. Sullivan brings a claim for unfair dismissal and disability discrimination, both on grounds of failure to make reasonable adjustments and also discrimination because he's been dismissed arising from his disability. It's a reason arising from his disability, and also direct disability discrimination. So he brings all claims against his employer, and his employer defend the claims on the basis that Mr. Sullivan does not have a disability. They say that the delusional period in 2013, March to September of 2013, and the delusional period in 2017, yes, were two periods where there was a substantial adverse impact on his ability to do day-to-day activities, but it was not a matter that was likely to recur again, and therefore it is not a disability because it's not lasted 12 months or more. Both the two periods of time were added together and for the whole period, because there's a period in between, which is May 2013 through to April of 2017, when he was fine. He was bad timekeeping, record keeping, etc. He was back to his normal chaotic self, but not the impact of the delusional. And Mr. Sullivan said, well, hold on a minute. I had a delusional period in 2013. I had a delusional period in 2017. This is likely to recur again. And I do have a disability. And that condition that I suffered, impairment, was an ongoing condition from 2013 onwards, and therefore it has lasted more than 12 months, and it does have a substantial adverse impact on my ability to do day-to-day activities. And the tribunal looked at all the facts as they saw it. They had an occupational health report which said that it's likely to fall under the Equality Act. The tribunal looked at all the facts, and in their view, as at the date of the discriminatory act that Mr. Sullivan was relying upon, the act being dismissal in September of 2017, there'd been two occasions when there'd been delusional a condition of the type that Mr. Sullivan described, and that meant, in their view, it was not likely to recur again. And they looked at the facts as they saw them. They looked at Mr. Sullivan's impact statement, which described the conditions and the day-to-day activities he could and couldn't do. And they said, no, we think that this is not a substantial adverse impact in your ability in the period of time between the two periods of delusional condition. And Mr. Sullivan appealed that decision and said, the tribunal had applied the wrong test, that my condition was continuing, and because my condition was continuing, I therefore had that substantial adverse impact. And the EAT and the Court of Appeal, which is the decision that came out 2 weeks ago, both agreed that the tribunal was correct in its decision-making process. You could have a condition that was in existence for a period of time, but that condition is not having a substantial adverse impact on the individual's ability to do day-to-day activities. And that's what's the 12 months and or more period that's being thought through by the tribunal. Now, when Dean started this webinar, he said that about the legal information that we're passing on today, it's not advice, because each facts are changing and the facts are always different in different cases. And that's exactly what this case identifies. With any matter that involves the dismissal of an individual, and particularly relating to discrimination, it's the facts of the case that are wholly relevant in determining whether that's a successful claim or not for the individual concerned. And the law then has to be applied to those facts in order to determine that liability. So in this particular case, Mr. Sullivan was not able to persuade the tribunal. In fact, his lawyer was not able to persuade the tribunal that Mr. Sullivan did indeed have a disability at the date of the act of discrimination that Mr. Sullivan alleged, which was the dismissal in September of 2017. That doesn't mean that any recurrent condition such as depression and or anxiety and or this delusional condition that Mr. Sullivan had is always going to not be a disability if it's occurring in particular chunks of time. It could be a disability, but in this instance, Mr. Sullivan was not able to persuade the tribunal of that fact, nor at appeal and nor at the Court of Appeal. Mr. Sullivan did win his unfair dismissal claim. It was decided that the way he'd been dismissed in September of 2017 was unfair, the timekeeping, etc. But he would have been dismissed within a very short period of time after September had they followed a fair procedure. So he did win one element of his claim. So I think the thing that you take away from this case is don't always assume that the occupational health report, whilst it may be saying it's a disability, is necessarily what the tribunal will follow in the tribunal proceedings, because it's another piece of evidence and ultimately it's for the tribunal to decide. But equally, sift through the facts to see whether there's this substantial adverse impact. And that's something that's more than minor, more than trivial. So an example would be, so the individual may be able to cook their tea or their dinner or whatever, but they're having difficulty doing that. That has a substantial adverse impact. They may be able to go to work, but they're having difficulty doing that for the period of time during which they have the condition that they're relying upon. So it's looking at what they are suffering from, what the impairment is, and what the impact has on that day-to-day activity. Thank you.
That's great, thanks, Shona. And I think in practice, where we've got people suffering from, well, in the last 2 years, there's been a huge mental health pandemic as well as a viral pandemic as well. And particularly 6 months in, there was lots of reports of people's mental health suffering, and depression can be one of those conditions where when people are in a period of depression, it can be a disability if it's particularly severe. Other times it's not. And so this case is a good example of, as you say, companies are entitled to, whilst it's the tribunal's decision, ultimately companies are able to, or they should make their own minds up and not blindly rely upon an occupational health report, for example, which can be put together quite quickly, I suppose. And I think we had a brief discussion about cases of long COVID as well. Yeah, so and this case is relevant with those types of conditions. Great, okay, no questions, none at the moment, but feel free to ask questions if anybody wishes to. And okay, that's great, thanks, Shona. Now we're just going to move on to Harriet's section, and she's going to discuss another interesting case that's come out about whistleblowing. So over to you, Harriet.
Lovely, thanks, Dean. Yeah, I'm going to be looking at a recent EAT decision, looking at whose motivation within an employer when dismissing somebody is relevant. And in this case, it was an employee claimed automatic unfair dismissal when they'd blown the whistle, but it also applies in ordinary unfair dismissal claims as well. And the case is Kong and Gulf International Bank Limited. So the main point, I think, I'll sort of start with the main takeaway just to put it in context. the EAT has really clarified that when you're determining the reason for dismissal in an unfair dismissal claim, it's only going to be the person who made the decision to dismiss scenes. So just to look a little bit at the sort of the relevant law here, because it's quite complicated in terms of you know, how whistleblowing claims work, etc. So I'll just go through that brief. Object to any detriment by their employer on the grounds they've made a protected disclosure, and that's section 47B of the Employment Rights Act. But also, if the main reason for an employee's dismissal is the fact that they've made a protected disclosure, the dismissal will be automatically unfair, and that's section 103A of the Employment Rights Act. An important case that's referred to in this case is the case of Orr and Milton Keynes, and that was the case that held that an employer, they can't be deemed to have knowledge of all facts known to all its employees when deciding whether it was reasonable for it to dismiss. And what an employer has to do is carry out a fair and thorough investigation, and if they've done that, it's only the facts that are known to the actual decision maker that are relevant in determining whether the dismissal was fair or not. And that was a 2011 case. And then in 2019, we had the case of Royal Mail Group and Duty, which caused quite a lot of interest, certainly amongst employment lawyers. And it went all the way to the Supreme Court. And ultimately, they held that an employer was liable for automatic unfair dismissal as a result of protected disclosures, even though the person who made the decision to dismiss the employee was actually unaware of the protected disclosures. So this provides a sort of certain gloss on that previous case of Orr I mentioned, where it's normally just the person who makes the decision to dismiss. And what they held was where there's a manager, it's referred to as the hierarchy of responsibility of above an employee, so somebody more senior, if they decided the employee should be dismissed because of protected disclosures, but they then hid this reason behind, in this case, allegations of poor performance, which were then adopted in good faith by the decision maker, the real reason for the dismissal here was the protected disclosures. So ultimately, in this case, and it actually overturned the decision of the EAT in the Court of Appeal, it was found that there wasn't automatically unfair dismissal because it was the hidden reason that was actually classed as a reason for dismissal. But they did hold that normally, when you're looking for the reason for dismissal, courts don't need to generally look any further than the reasons given by the decision maker. But if the real reason's been hidden, then they do need to look behind sort of this invention. And the reason I'm referring to this is because this is really the crux of Ms. Kong's appeal in her case, that she was trying to apply this principle in the case of duty. And it's interesting that how the court has clarified that actually it's only going to apply in really extreme cases, as in the case of duty, where the manager had actually fabricated performance concerns that were then relied on. So just to put this in context and look at the facts of the Kong case, so you can see how it differs and why the tribunal, the EAT, came to the decision it did. So Mrs. Kong was employed by Gulf International Bank as head of audit, and she reported directly to a Mr. Mohammed, who was the group chief auditor. Ms. Kong raised several concerns with GIB's head of legal, Ms. Harding, about an agreement relating to one of GIB's financial products. And it was accepted that these concerns were protected disclosures. Ms. Harding disagreed with Ms. Kong and confronted her about her disclosures. And during this conversation, Ms. Kong questioned Ms. Harding's legal awareness, and Ms. Harding was then upset, complained to GIB's head of HR and the CEO, and she complained that Ms. Kong had questioned her integrity. And it's important, the difference here, because that's what Ms. Kong tries to use as shown as an invention to try and get her dismissed. And Ms. Harding then sort of limited her interaction with Ms. Kong, and certainly gave the head of HR the impression she couldn't work with her anymore because of this slur that had been put on her integrity. The head of HR, CEO, then informed the group chief auditor of this incident, and together they decided that Ms. Kong should be dismissed because her manner meant that colleagues didn't want to work with her. And apparently this has happened in the past, potentially with other individuals. So they saw a bit of a pattern. And her dismissal letter specifically referred to Ms. Kong having questioned Ms. Harding's integrity when she'd actually questioned her legal awareness. And it was also noted here that the concerns that Ms. Kong had raised were included in the final version of the audit report, which all the decision makers were aware of. So it wasn't being swept under the carpet at all. So Ms. Kong then brought claims for unlawful detriment and automatic unfair dismissal and ordinary unfair dismissal as well. And the former two claims are having raised the protected disclosures. Interestingly, the claim for unlawful detriment as a result of how Ms. Harding treated Ms. Kong would have succeeded, but were out of time. So it was found that she did subject her to a detriment by sort of giving her the silent treatment, etc. But importantly, the claim of ordinary unfair dismissal did also succeed. So she did have a victory there, but the claim for automatic unfair dismissal failed. And the main reason was that the tribunal found that the decision makers dismissed Ms. Kong because of her conduct and not her protected disclosures. So in the appeal, Ms. Kong argued that Ms. Harding had sought her dismissal because of the protected disclosures and that her motivation should therefore be attributed to GIB, as in the case of duty. So saying that Ms. Harding's motivation was the protected disclosures and therefore that should be attributed as the reason for dismissal. And the EAT didn't agree with that. They said the tribunal were right not to attribute Ms. Harding's motivation and confirmed that this principle in duty is rarely going to apply because they found that Ms. Harding's complaints that Ms. Kong had criticised her integrity rather than her legal awareness just wasn't remotely the sort of manipulation or invention necessary for the principle in duty to apply. And remember, in duty, as said, the claimant's manager had entirely invented performance concerns, which the decision maker adopted, was unaware of the invention, was unaware of any of the protected disclosures. So you've got a very different sort of level of manipulation in that kind of case. And also, as I said, the decision makers were aware of the audit report. They were aware of the interactions between Ms. Kong and Ms. Harding. They weren't solely dependent on Ms. Harding's oral account of the basic facts, unlike in duty. So they weren't relying on her for the facts and the information. And also there was no finding that Ms. Harding had sought Ms. Kong's dismissal. So I think they decided that the tribunal was right to find that the decision makers hadn't been materially misled by Ms. Harding in this case, and it's clear that what the decision makers were motivated by wasn't what Ms. Kong had said. It wasn't the content or the fact of her disclosures, but the way in which she conveyed her personal criticisms to Ms. Harding, and you could separate those two things. So I think in conclusion, I think we can now be clearer, if we weren't already, but it's good to have it confirmed by the EAT that where a decision to dismiss that's been taken in good faith, not just for a wrong reason, but for a reason which the employee's line manager has sort of dishonestly constructed, are really going to be rare. So in most cases, it will still only be the reasons of the decision maker that are going to be relevant to an unfair dismissal claim. So this principle in duty of the manipulation and therefore the risk of an automatic unfair dismissal claim where the decision maker has no idea about it are going to be really few and far between. And that's the end of my summary.
That's great. Thanks very much, Harriet. No questions from anyone so far, other than one from Rosie, and she's asked whether we could kindly let everyone know the names or links for the cases. So I'm happy to drop that in the chat box. So Shona or Harriet, if you can email me maybe the full name of the case, and then I'll drop that in the chat function, or otherwise you can just type it in yourselves one way or the other. But yeah, sure. I'm happy to share the names and the full links for the cases with everyone, and we'll do that shortly. Okay, no questions, which must be a first. So we're just going to move on to the final section of today's webinar, which is all about, again, a growing topic, also a growing topic of concern for many, I think, which is the employers monitoring employees, which is absolutely on a growth sector since since lockdown and certainly since hybrid working has come around. And Dominic's going to talk to us all about that. So over to you, Dominic.
Thank you, Dean. So as Dean mentioned, I will be looking at monitoring employees. So first of all, what we'll look at is first of all, what is monitoring by employers and how can it be done? Monitoring is employers looking at what their employees are doing, and that can be either overtly or covertly during working hours. There are, of course, a number of methods by which employers might seek to monitor their employees' use of electronic systems in the workplace. This can be through email content and traffic, internet use, telephone use, but also CCTV. However, this is a separate topic. There are different levels of monitoring that can be carried out with regards to these. For example, there are spot checks within the organisation without reference to particular individuals, and this can monitor which sites are visited, how often, the number of email messages sent or received, calls or length of calls received or made. There can also be specific checks on individuals for any sort of reasons, potentially disciplinary reasons, and monitoring all of those mentioned. Then there's also the monitoring the content of calls or emails, whether that's on an individual or random basis, say weekly, monthly. As Dean mentioned, we wanted to speak about monitoring now, as there are programs used to monitor employees whilst they are working from home, and they are increasing in demand. There are certain software which enables managers to monitor employees by scanning screenshots, which can catch you at any time, which can be, of course, in your private home while working from home in your bedroom. But it can also monitor login times and keystrokes, and potentially whether your mouse is active or not, which of course is useful for employers while employees are working from home. There is, of course, actually an example of an employee in 2017 who found a very small rectangular box mounted under his desk in his workplace. It actually had a heat and motion sensor, which was silently logging how long he'd been spending at his station, which shows that employers can attempt to monitor their employees using very advanced methods. So then we will look at, is monitoring employees actually legal? Unfortunately, the answer does not come down to a simple yes or no. It's rather that employers can only monitor employees' actions to prevent liability arising in certain circumstances and by means of specific policies and methods, which I will discuss later in my talk. Then we will look at areas of law which govern monitoring employees. So monitoring employees at work brings up a wealth of legal issues governed by a number of different pieces of legislation. So there is a lot to consider. There is no data privacy law in the UK which specifically governs monitoring of employees or other workers. And that means that employers are neither expressly permitted to monitor, nor are they prohibited from doing so. Instead, as the various methods of monitoring have developed over recent years, so has the regulatory framework which is governing their use. The first area of law that we have to consider is Article 8 of the European Convention of Human Rights, as incorporated into UK law by the Human Rights Act of 1998. And this provides individuals with the right to respect for private and family life and correspondence. The second area of law that we'll look at is the General Data Protection Regulations, commonly referred to as GDPR. And that's because electronic forms of workplace surveillance involve the processing of personal data. And the third area of law that we will look at is the Investigatory Powers Act of 2016, regarding the statutory regime governing the interception of electronic communications. And finally, we need to consider the duty of trust and confidence implied into an employee's contract of employment, whereby the monitoring of the employee's activities may constitute a breach of this and give rise to a constructive dismissal claim. So moving on to the first area of law, and that is the Article 8 European Convention of Human Rights that I mentioned. So unfortunately, there is not enough time for me to go into any specific detail with regards to this, but by way of a summary, the first area of law, like I mentioned, Article 8 is the right to privacy. It states that everyone has a right to respect for his private and family life, his home, and his correspondence. However, this is not an absolute right. The required balancing act is known as the doctrine of proportionality, and I will refer to that a couple of times throughout my talk, and it involves the following steps. That's first of all, identifying a legitimate objective, ensuring it is sufficiently important to justify limiting the right, which is essentially balancing the aim against the effects, and then ensuring the method chosen is no more than necessary to accomplish the identified objective. So the case law surrounding this area of law is very interesting, and it tends to focus on the question of whether the employee had a reasonable expectation of privacy in relation to the communications in question. If not, Article 8 will not be engaged. So therefore, if the employee did have a reasonable expectation of privacy, the court will then go on to consider whether that interference by the employer with that privacy was in accordance with the law, and then it was proportionate, as I just mentioned. So looking at that in a real life perspective, from an employee and employer point of view, there is the case of Halford and the UK, where there was a breach of Article 8 when a police inspector's telephone calls from her office were tapped. She had been given no indication that her calls would be monitored, and in fact, one of the two office telephones were explicitly designated as being for her private use. And these factors, as I just mentioned, gave rise to a reasonable expectation of privacy that the employee had, and therefore engaged Article 8 and caused a breach by the employer. Then the European Court of Human Rights also considered the monitoring of an employee's telephone, email, and internet usage in Copland and the United Kingdom. And the European Court of Human Rights concluded that Article 8 was infringed where, firstly, there was no information technology policy in the workplace, and the employee was not told that they might be monitored. And I will come on to the use of policies later in this talk. And then the second area of law that I will look at is data protection. So electronic forms of workplace surveillance involve the processing of personal data, which is regulated by the UK GDPR and the Data Protection Act of 2018. Monitoring employees' use of email and internet involves the processing of personal data, and so data protection legislation must be considered by the employer. The data protection principles and Part 3 of the Employment Practices Code are relevant to the employers when monitoring is carried out. So personal data may not be processed unless there is a lawful basis for processing under the UK GDPR. Employees must also be informed of the basis for the processing and the purposes for which it will be processed. So looking at Part 3 of the Employment Practices Code that I just mentioned, and it contains very useful guidance for employers on monitoring work. Workers' private lives usually extend into the workplace, and employees have an expectation of privacy, even where they have been informed that monitoring may take place. For monitoring to be justified, the proportionality test must be met, as I mentioned previously, and a limited number of staff should have access to this information obtained through monitoring. They should have received the appropriate training, and data obtained through the monitoring should, of course, be secure. Furthermore, the UK GDPR requires employers to undertake data protection impact assessments to assess the necessity and proportionality of planned data processing. Employee monitoring is likely to amount to a high-risk processing, which will, of course, in turn, require a data protection impact assessment. And this should document the specific need for the monitoring, why the form of monitoring proposed is proportionate to meeting this need. The second key theme, in terms of data protection compliance in this area, is the provision of full information to workers about any monitoring or testing. Employers must meet a high standard in terms of the level of information provided. It is not enough, for example, just to tell employees that their email is being monitored, whether you send that as a company-wide email or otherwise. Employees must have a clear understanding of when the information about their email or internet use will be obtained, why it's being obtained, how this information will be used, and who it will in turn be disclosed to. So then the third area of law, which is relevant, is the Investigatory Powers Act of 2016. This makes it unlawful in certain circumstances to intercept a communication in the course of its transmission in the UK. So under the Act, communication is defined to include anything comprising speech, music, sounds, visual images, or data of any description, so it's clearly wide-ranging. If employers do any of the actions mentioned, it is an offence unless the person has either the right to control the operation or use of the system, or the express or implied consent of a person with the right to control the operation or use of the system to carry out the interception. So obtaining an employee's consent to possible interception may be an option for employers, particularly for internal emails and telephone calls. It does, of course, become more problematic in the case of external emails, as the employer must be able to show that it has reasonable grounds to believe that both the sender and the recipient have consented. In the absence of consent, the employers might nevertheless be able to monitor lawfully, relying on the monitoring and record-keeping regulations. And businesses can monitor or record communications without consent for various reasons, with the most relevant to employment law being to establish the existence of facts, as I previously mentioned, potentially in disciplinary proceedings, and to investigate or detect the unauthorized use of the telecommunication system. There are unfortunately restrictions to this, one of which includes the employer having made all reasonable efforts to inform every person who may use the telecommunication systems that interception might actually take place. So how is all this relevant to employers? We have to look at what an employer needs to do to monitor effectively. Step one is, at James Chase, we highly recommend for an employee's contract to contain a contract clause under which the employee might or would give their generic consent to monitoring. This would generally make them aware of the employer's ability to monitor. It would also help with issues where an employer requires the use of an employee's emails to use as evidence in disciplinary proceedings. And if you do not have this clause in a contract and would be looking to implement this, do let us know, and we can, of course, assist with the contract variation process as express consent is necessary. Then step two, the importance of providing information to employees about any monitoring means that employers should have an electronic communications policy. As I previously mentioned, now I will go into, first of all, what it should contain and then how it should be communicated. So firstly, what should it contain? For the purposes of employee monitoring, it is essential that it contains a full statement for the purposes of which the monitoring may be undertaken, the extent of the monitoring and the means used. As misuse of an employer's IT systems is generally regarded as misconduct and may in some cases amount to gross misconduct, a clear policy on usage will reduce the risk of unfair dismissal claims arising if the employer does in fact dismiss an employee. Although, of course, simply stating that something amounts to gross misconduct in a policy will not mean that the dismissal is always fair. In connection with this, it should also state that the company equipment, such as laptops and mobile phones, should only be used for work-related matters and not personal matters. Also, the technology should not be used to harass other employees or damage the company's reputation in any way, which in turn means if the employer thought the policy was being abused by any employee, they could then look to view web traffic and emails. The policy should also be regularly updated to keep current with changing laws, business practices, and technologies. And then the second point that I mentioned is how should it be communicated? I've kind of mentioned various times about raising awareness, and that's really one of the key points. For these purposes, the more awareness raised by the employer, the better. Examples to raise awareness further: the policy should be given to employees at the start of their employment. Staff should receive training on what the policy means and how it operates. Employees should be asked to indicate that they have read the policy and accepted its terms. And also, we would recommend circulating a staff handbook annually. So in addition, it is important that the policy is followed up with action to ensure that employees do comply with it. Examples of this is managers being trained about data protection and it's relevant to their responsibilities, but also including security of personal data in the workplace. And then finally, an example of how this works in practice is actually shown in a very interesting case, which is the case of Simpkin and Berkeley Group Holdings. The High Court actually rejected the employee, Mr. Simpkin's application to restrain his employer from relying on allegedly privileged documents in the context of an employment dispute. So the documents were sent from his work computer to his personal email account. The court held that the email was not confidential because the employee had signed his employer's IT policy, which provided that email sent and received on its IT systems were company property. The employer's IT department had full access to all the emails, including the one sent, and Mr. Simpkin, the employee's personal assistant, had direct access to his emails, and the attachment had been created in the course of his employment using his employer's IT system. So this case is a clear example of how powerful, well-written and well-communicated electronic communications policy can be. And that's all from me.
Okay, that's great. Thanks, Dom. And yeah, I totally agree with everything you said. And people, I guess, don't realise that just monitoring employees and work, it does throw up, 4 pretty large legal areas. You've got the Article 8 right to privacy. You've got data protection, GDPR. You've also got the Investigatory Powers Act. And on top of that, you've got things like trust and confidence and constructive dismissal. So, and there's no one law that guides employees through this. Each case has to be looked at with the 4 different, within the 4 different areas. So it's fiendishly complicated. I think if there's one thing to take away from this is that if you are monitoring employees, looking at emails and things, you just, you have to let them know about it, and not keeping it covert can be exceptionally dangerous. Also use of CCTV as well, which falls outside the scope of this webinar. There's rules for that, and again, covert recording using CCTV is a genuinely dangerous thing to do. But we always recommend having a really good clause in the employment contract that says that the employee gives consent to be monitored, and that none of the communications on certainly the work, the employee's IT, the laptops and mobile phones that are private. And also, and this is one area of law that I've really seen grow in the last 10 years or so since I've been practicing, 20 years since I've been practicing. The email and internet policy previously was very basic. Now an awful lot a heck of a lot more needs to go in there. And it's been a real growth area, and not just on monitoring, but for everything else as well. And also putting your rules in there about what is and is not acceptable use can actually give you a reason. In some circumstances, I have to be careful. It can give a reason to monitor. For example, if somebody is misusing the system, sending messages which could be harassing another colleague. But it's all about getting consent and raising awareness, essentially, I think, in this most practical sense. But thanks, Tom, that was great. Just moving on to the questions.
Can I just stay on the subject? That's okay. Yeah. There's a 1990 Act, a Computer Misuse Act, and that, excuse me, says that the unauthorized inspection of a computer system is a criminal offence. Where that is relevant to employment law is if employers allow employees, or indeed their consultants or contractors, to use their personal equipment. Dominic referred earlier to the 2016 Act, which says that if you are the provider of the system on which work is done, then you can go into that system, and you do need consent to monitor the personal information. But this 1990 Act is suggesting that if an individual is using their personal computer and going into the work system on that personal computer, it's a criminal offence if you check that system and their use of it without their authorization. So that in itself goes slightly further than the 2016 Act, because I've noticed just in the home working and hybrid working, employers have become slightly lax as to what device people are working on, whether it's a home computer, home telephone, or whatever it is. It's let's just get the work done and it'll all be fine. So that's another thing to think of. I wonder, Dominic, because you said about the consent in the contract, and there's also quite a lot written about privacy statements that employees, when they first start work, they sign quite a long privacy statement in some employer establishments that sets out, you talk about the proportionality thing, and it's actually addressing at the very outset what the employer regards as proportionate. We will do this because our type of work is X, and we need to monitor in order to make sure that Y is the outcome. And I wonder, what do you think about having that proportionality thing in advance, and and if it needs, maybe if it needs to change somewhere along the line, that you can add to it, maybe like a list of gross misconduct events where it says this list is not exhaustive. You could say that reason for proportionality that we've just given you to show how proportionate we have been or could be or will be isn't exhaustive, but just to give you the gist of why we might monitor. Do you reckon that's, it wouldn't be in the contract, but it could be in this privacy statement that you do for employers?
Yeah, no, I agree. It can only be beneficial, really. Of course, if you're talking about kind of proportionality in that sense, then I suppose an employer can't just say what they believe is proportionate. But yeah, I mean, it can only benefit, because kind of what I mentioned throughout really was communicating that to the employee, and not just communicating that they're being monitored. Say, like the crazy case at the start where they're sticking it under their desk to heat sensor, but why they're doing it as well. So that's only going to benefit and kind of communicate to the employee throughout, I suppose. So I do agree that would benefit, yes.
I think in that heat sensor thing, I think I trained the dog to move the mouse in some way.
Yeah, the employer actually said that they were doing it to check whether they were coming in and out of the office, but they had their own tap cards that they would do to come in and out of the office. So
it's just a classic example of doing things without the employee's knowledge or consent, and showing you exactly right. You know, the more information that's communicated to employees, the more regularly it's communicated, and the better for the employer. So knowing what the employer believes is proportionate is good. And as Domi have already mentioned, under data protection, it's not just getting consent to monitor doesn't work anymore. In other legislation it does, but just data protection it doesn't. So letting people know a lot more about what information, what data will be monitored, how will it be collected, who can see it, how it'll be used, etc. By far the more the better. So I think that's a good place to put that shown actually in the privacy notice, because it's too much for the contract, which needs to be short and punchy. But yeah, and I think one thing that we do with our clients is, you know, we always, when new contracts are done, the privacy notice goes with that now as well. So it can form part of your employment. One of the 8 essential policies, I say, the employee side of data protection, and that policy privacy can be in there as well. And now a much enlarged email and internet or electronic communications policy. That's great.
It's just one other little thing, which is in Northern Ireland, you have to monitor this monitoring from a slightly different angle. You have to monitor the number of individuals you employ and religion in order to account for the proportion of Protestants and Catholics in particular employed within Northern Irish businesses. So that's a monitoring which employees, I have to say, it's a sort of, I really don't want to give you this information, but it's there as a requirement. So that's monitoring for in order to be able to comply with the Fair Employment Act. That's relevant if you've got an establishment there. And I suppose the pay gap, you have to monitor salaries, etc. But you do that on a no names basis. That can all be done on a job rather than names. So there's monitoring, as I say, from a different angle.
Great, and just going back to something you mentioned earlier, Shona, actually as well, about bring your own device. Again, we'd recommend a specific, it sounds really boring here, but it's good to have a specific bring your own device policy, because you can put the rules in there, you can explain how it should be used, how it shouldn't be used if you're using your own devices. And it's just quite terrifying sometimes, the amount of data that's uploaded onto employees' personal devices, as you said earlier, and it's something that resonated with a lot of the webinars that we do. When everybody started to work from home in March 2020, it was an emergency state of affairs at the time, and things were just done just to get the work done. Now it's calmed down, everything should be regularized now. And yeah, bring your own device rather than a BYOB, as I almost said then. A BYOD device is definitely a good idea. Okay, so if that's what you do.
We've got a question just there about covert recording, about similar regulations with employees covertly recording without the colleagues' consent. There's two levels there. We had a case where an employee recorded disciplinary meetings that he was attending. He turned now it's easy, just turn your iPhone on and put to record and keep it in your pocket, and it's a pretty good recording. And when we got to, well, disclosure stage in tribunal, this recording was produced, and the individual was allowed to use it, even though it was a covert recording, on the basis that the judge decided that there was information that was relevant to it. But what we then wanted to have was the actual recording itself rather than the transcript. And that was because the individual had asserted that he'd been shouted at. And in fact, this recording showed the exact opposite. Nobody was shouting at all at the individual. And so it was very helpful for us to use that recording as a soundtrack rather than as a transcript. So no, there aren't. Other colleagues, if you leave the phone on and leave the room and you record people whilst you're out of the room, you're not allowed to use that. So that would be a covert recording where the individual had recorded people and they were not in the room. If you are in the room and that phone is surreptitiously recording, a tribunal will, on balance, allow that evidence in. In terms of whether that would be disciplinary action, I suggest I would put in my disciplinary policy if somebody was covertly recording. That is a potential disciplinary offence, because I don't like it as a means of gaining information. Don't know what anybody else thinks.
Yeah, that's right. I mean, I was going to say it could be an article. I'm just going to, the question is, sorry for those who are watching the recording of the webinar, are there similar regulations around employees covertly recording other colleagues without their consent? And I mean, there could be an Article 8 right of privacy issue here, potentially. But the thing that's really leaping out in my mind is it could be misconduct or gross misconduct, you know, I think. And you can have a code of conduct that makes it quite clear that you shouldn't be covertly recording your employees, your colleagues, sorry, not as an employee. This is an employee recording another employee for whatever reason that we have. It could be viewed as an act of misconduct, and also for some clients, we have it written into the disciplinary policy that covert recordings are, recordings without the employer's knowledge are not allowed of other colleagues. In disciplinary or grievance meetings, people do that quite a lot. But you can make it a misconduct or disciplinary offence if people do that as well. Don't know the specific answer for data protection because it's employee versus employee. But because a lot of the guidance we look at is employer and employee, but I would imagine there could be a data protection issue as well, but I don't know the specific answer.
There is a situation though where, you know, with bullying and harassment, often the key feature is that the bullier or harasser gets the individual on their own, and that's a he said, she said, he said, she said, she said, whatever, the mix of who said what, but it's one against one in terms of this person harassed me and another person saying, well, I didn't harass them, I didn't bully them. And that recording could be the only way the individual thinks that they're going to get information that anybody will believe them, that this is going on. So there's a fun balance here in ensuring that you're providing a safe place of work. If we start having something too draconian in terms of recording. So it has to be a thought through policy that you put in place.
Yeah, that's right. And I think it's the motivation behind the recording as well is important. If someone's recording someone else to prevent harassment, that, you know, could be seen to be a good thing in the circumstances. And you're right, in the court process, quite often these recordings will be allowed in as evidence, and that's a separate issue. And obviously, if somebody has left the business and they're recording you can't discipline them anymore because they're not employed. So yeah, just you think about that. But yeah, there's no specific regulations on employees recording other employees. And Shona, you've kindly answered the question that Philip wrote in, which is great. I may read that out at the end. We do have another live question in the Q&A box from an anonymous attendee. And that question is, should an email and internet policy be in the contract, or is it acceptable to be in a staff handbook? I have an answer for that, unless anybody else wants to go. Okay, it's me then, right, fine. Yes, I mean, well, the whole policy shouldn't be in the contract, but certain provisions should be in the contract. You can have a consent to monitor clause in the contract. Also, use of social media can be in the contract as well. We've got a very decent social media clause saying what people can and can't do with their social media insofar as it relates to work in the contract. And then separately, yeah, it's a very good idea, as we keep saying, to have all of this wrapped up in a very good policy in the staff handbook. You can make part of the staff handbook contractual. We're big fans of that as well. Typically, whenever you want an employee to do something for you, you make that section contractual. You can have the handbook in two parts. So for example, the whistleblowing part can be contractual, the email and the internet part can be contractual as well. Things where you want a bit more freedom, like the disciplinary and grievance process, you may need to adjust, you make that non-contractual. So the answer to the question is, I think both you can have it in the contract and also in the contractual section of the staff handbook. And if your provisions about monitoring in your policy, not in your contract, you want that policy to be contractual ideally, okay? I think that's all of the live questions. Shona, but whilst I'm reading out Philip's question and your answer to it, can you just get the name of the disability case that you discussed earlier, so I don't have it in front of me, I'm sorry.
Yes, excuse me, it is Mr. Sullivan and Berry Capital. What I'll do is ask Julie. I can see that Harriet has very efficiently sent around her name. I'll have Julie send out to all attendees the link to Sullivan and Berry Capital. I have the nice hard copy, so that didn't work so well through the computer system.
If there's any consolation, this is what I've been using as well. So
yes.
Apologies for the environment. Okay, and just in the last minute, I'll just read this out so everybody can see it, and those watching the recording can get it as well. So Philip has said, what is the most suitable approach for a company to support an employee? Bear with me. Support an employee with a disability who has a high sickness absence record and is underperforming in the role. And Shona wrote an answer, says, as a first step, you may wish to meet with the employee to review what reasonable adjustments are needed, absolutely, to allow the employee to reduce their absence levels and or discuss reducing their hours to a level where it can be sustained. And then there's, again, as Shona said, there's other websites out there as well about with information linked to the disability and what reasonable adjustments should be followed or use occupational health. So that's right. So if, for example, if the disability, I don't know if it's a mental illness, for example, there's other charities available out there. But as you say, getting medical evidence as well. And it is a great idea using our occupational health and controlling the questions you ask the doctors as well. I'm not a big fan personally of asking a doctor, is this person disabled? Yes, stroke, no. That can be very black or white. What we tend to do is split the statutory test for disability into different questions. Does this person have a physical or mental impairment? Yes or no. Does it last for longer than 12 months? Does it substantially affect their day-to-day activities, etc.? And then you can form your own management opinion, because it can be quite tricky. If is this person disabled? Yes, then you have to backtrack on that as well. But it's, yeah, so I think running through that process as well and using good medical advice is a good idea. Okay, and I think we've just double checking. I think we've covered all of the questions. Thanks very much for yeah, that's right. Thanks very much for attending, everyone. It's been great to have you with us. Just a quick reminder that the information we've covered today is accurate as of the 25th of November, 2021. We will be doing one of these again, I believe, in December. So hopefully we'll see you all then. And thanks very much for attending once again. Okay, take care and bye-bye.
Bye-bye.
Bye.